A very good evening. The last judges to question the government's Brexit strategy were labelled enemies of the people. Well, today the Supreme Court made clear its concerns were legal, not political. On day one of the government's historic challenge over its power to trigger Brexit, the Attorney General argued that was the logical conclusion of a process Parliament were fully involved in. All 11 Supreme Court judges are sitting on the case, and in a moment we'll look at which of them stood out on day one of the hearing. But first, Sky senior correspondent Michelle Clifford reports.
The setting for a showdown which would not only pit some of the finest legal brains in Britain against each other, but require the UK's top judges to decide who'd got it right. And outside, a handful of sceptics who'd already decided they didn't trust the Supreme Court justices to make a fair call on Brexit.
We believe that unelected judges, we believe they've got vested interests in Europe, and we don't feel that we're going to get an unbiased opinion.
We voted in a fair democracy, and here we are today, arguing over it.
Such are the emotions that Gina Miller, whose victory in the High Court triggered this government appeal, required security to attend. And threats to her and others was the first thing the President of the Supreme Court addressed on opening.
Anyone who communicates such threats or abuse should be aware that there are legal powers designed to ensure that access to the courts is available to everybody.
And everyone should be clear, he added, that here politics was irrelevant.
This appeal is concerned with legal issues, and as judges, our duty is to consider those issues impartially and to decide the case according to the law. That is what we will do.
And with that, it was over to the Attorney General to kick off for the government.
This is a case of great constitutional significance.
The High Court, he insisted, got it wrong. The government can use so-called prerogative powers to start Brexit without Parliament's say-so.
At the heart of the referendum campaign between Remainers and Leavers was the proposition that the referendum would provide the definitive answer to the question of our future inside or outside the European Union. And the assumption that this was so was surely clear from the vigour with which the campaign was fought by both sides.
If the Attorney General had the pressure of opening, then it was James Eadie QC who would be forensically taken to task by the justices. They pressed him over and over on the use of prerogative power, which would deny MPs the right to trigger Article 50.
The conduct of foreign affairs involves myriad decisions, a daily exercise of power, a series of judgment calls, the negotiations between sovereign states on the international plane leading to the conclusion and indeed to the withdrawal from agreements that are so made.
Are these summarised in your case?
Do they proceed on the assumption that that's correct, or do they discuss that?
Is it your submission that there is a tougher test to be applied?
Previous cases were frequently cited, and the search for relevant documents not infrequently caused confusion.
Test the system to destruction by the end of this case.
Yes, you are right. You are right, Mr.
I am right. Good. At least that's something.
On this point.
An occasional levity in a court which had none of the legal formality of wigs and gowns, but no one was in any doubt about the seriousness of what is being decided.
He's persuaded the judges it's possible to use these prerogative powers to amend the treaties and to give those amendments effect here in the laws of the United Kingdom. Quite another thing to persuade them that you can use these prerogative powers to pull the UK out of the EU completely. It doesn't follow. He said it follows as a matter of logic, but I'm not sure they were persuaded.
But if the government wanted to convince pro-EU campaigners Parliament was not being cut out of the loop, it might have ensured its QC was better briefed on the Great Repeal Bill, which will allow MPs to vote on which bits of EU law should survive post-Brexit.
Do we have any evidence about that?
About the Great Repeal Bill?
Well, yes, about what it is, what it's going to do.
Watch the Attorney General sitting to Mr Eadie's left.
I think there's been a statement of the Conservative Party conference. Has there been anything else?
Pass. We'll double check and get you whatever there has been on that. But I think there's no more than that at the moment.
And the justices will likely hold him to that when he returns to court to continue fighting the government's corner before lawyers for the other side try to persuade the 11 that MPs should have a vote. Michelle Clifford, Sky News, at the Supreme Court in London.